And so this is something that I have a similar screen for every topic that we talk about. And this is just looking at Wet'suwet'en considerations when thinking about what to put into the custom election code with regard to chief and council eligibility. And so you can see it says 30 minutes for group discussion, but we only have one person here, so you get 30 minutes all to yourself today. And what we want to hear from you, and it's okay if you have nothing to add, just please let us know that, and then we'll move on, is whether you can think of any stories from long ago that you heard from your family members, or any songs or kind of historical accounts that you're aware of that teach you or teach Wet'suwet'en people about the types of characteristics or experience that should be required out of our leadership. And the idea is to look at how these Wet'suwet'en considerations fit into the picture of creating criteria for what a person must have in order to run for chief and council. Other things that you might have that come to mind are specific words. So there might be specific words or terms in the Wet'suwet'en language that come to your mind. And there might be certain things you've been described as laws of how things work. For example, things, how they work in the feast hall, or just other things that you've heard through history, through your grandparents, through your great-grandparents, maybe through your parents or aunties or uncles, or maybe through your hereditary chief. So is there anything that comes to mind with regards to Wet'suwet'en legal traditions that teach us about what a chief or councillor should come to the table with regards to either personal characteristics or experience? So right now for Witset, falling under the Indian Act with regards to its chief and council system, it's the Indian Act and the regulations made under the Indian Act that set out criteria to be on chief or council. And to be a councillor, a person has to be a member of Witset. And to be a chief, there is no requirement that a person has to be a member of Witset right now. Other than that, all candidates have to be 18 years of old on the date of the nomination meeting in order to be a candidate in an election. And there's no requirement that a person continue to maintain these criteria throughout their term. There's also a First Nations Election Act that is an alternative to the Indian Act. The Band Council can opt into the First Nations Election Act and regulations around council elections by way of Band Council resolution. And if they were to do so, the Indian Act rules would no longer apply and the First Nations Election Act rules would start to apply. So if Chief and Council had done that with regards to Witset, all candidates would have to be members of the First Nation in order to run for chief or council and be 18 years old on the date of the nomination. It doesn't distinguish between councillors and chiefs with regards to membership. So this, it doesn't distinguish in the same way as the Indian Act. So the difference with the First Nations Election Act would be that you do have to be a member in order to be the chief. Now we're going to move on to just a couple of alternative jurisdictions to see how they do things. And just to get people's minds thinking, this isn't to push, not intended to push any of these criteria on you. So when somebody's running for a BC provincial government position during our provincial elections, the rules for that are set out in the Election Act for eligibility. And the person must be 18 years of age or older on voting day. So that's the same as we have right now under the Indian Act. And they must be a Canadian citizen. So somebody who's a permanent resident, for example, in Canada would not be able to apply to run for election to be a member of legislature. They have to have been a resident in BC for at least 6 months prior to the date they get nominated, and they cannot run for a BC provincial government position while they are also holding a position in the federal government, an elected position in being a member of parliament. They also cannot be the chief electoral officer or deputy chief electoral officer. So if you want to have one of those positions in managing the election, you're not also allowed to run in the election. And then there's also this additional criteria that they cannot have been disqualified from running in the provincial election due to voting offenses or offenses that have to do with holding office. So vote buying, intimidation, corrupt voting, or subversion of an elector official. So interfering with an electoral official's duties. The BC government also has some rules regarding dual role restrictions, and this is the Eligibility to Hold Public Office Act. And so a member of the Legislative Assembly is disqualified. Oh, sorry, this is with regards to municipal elections. So if somebody is a member of the Legislative Assembly, they are not allowed to hold a local elected office. A mayor or councillor of a municipality or of the city of Vancouver, these are all the different positions that you're not allowed to hold if you are already a member of the Legislative Assembly. So there's no dual roles between a member of Legislative Assembly and also being a mayor or councillor of a municipality in Vancouver, being representative for a regional district, being on a park board, being a trustee for a school trustee. So that's with regards to the management of schools. Being a local trustee, this has to do with an island trust that's probably not relevant for Witset. And then the government can create other can prescribe other types of office that you're not allowed to hold as a dual role. With regards to local government, so this is people who want to be a mayor or a councillor of either a city or a municipality. Again, 18 years of older, again, must be a resident for at least 6 months in BC. Also, not have been found guilty of an election-related offense. Again, not have been disqualified in a previous term. But in addition to those which are the same as for holding provincial office, they also cannot have been convicted of and sentenced for indictable offense and be in custody. So they can't be in custody of the correctional system in jail at the time that they're applying to run for local government, and also cannot be a judge. So cannot be a judge of any of the courts in the province, and also cannot be involuntarily confined to a psychiatric facility or other institution. There's also some restrictions. So local government staff who wish to run for office in the local government, they have to take a leave of absence. So you're not allowed to be an employee for the city and also be a councillor for the city. People who provide contracted services to local governments, to cities, for example, may be eligible to be candidates, depending on whether or not they are an employee or independent contractor. Volunteers who receive compensation from the municipality or city for work that they're doing, they are allowed to run for office if they take a leave of absence and they resign from the volunteer work once they get elected. So they can't continue to be on committees, etc., for the city, for example, at the same time as running for office for mayor or councillor positions. If somebody's a BC public service employee and they seek nomination as a candidate in a local government election, for example, a city or municipality, then the duties of their elected office cannot conflict with their normal working hours. So a person who's a BC public service employee, so working for the province, is only allowed to sit on to be a mayor or councillor of a municipality in situations where the municipality would have to hold its meetings in the evenings and all their duties would have to be held outside of their working hours. And also they could not do anything that would put them into a conflict of interest. When it comes to federal government employees, federal and government employees require prior approval from the Public Service Commission of Canada to run for local government office. The commission is allowed to grant permission when it is satisfied that the person being a candidate will not impair or be perceived to impair their ability to complete their federal government job duties, and that it would not politically impair the person from completing their duties that they have to the federal government as an employee. We also have in British Columbia a Financial Disclosures Act, which is kind of a unique thing that I've not seen with regards to chief and council custom election codes in the past. So this is something that's an option if community's interested in it. So at the time that a nomination is accepted for somebody to run for provincial office, they have to do that in writing, and they also have to make certain disclosures to the government with regards to their personal finances, including corporate interests. So do they own any businesses? Are they shareholders in any businesses? Do they have any type of interest in a business? And other employment that they have, as well as the name of creditors, so people who they owe debt to, and any land ownership they have. And this is intended to not restrict them from running for office, but the idea is that in the way that they campaign and in the way that they operate, if they are elected into office, they've already disclosed all these things, and it makes it easier to determine when there's conflicts of interest that exist. Some other First Nations laws have interesting eligibility criteria that are unique and different than what you see in provincial, federal, and local governments. So the 18 years of age and being a member is very common. I see that in almost every election code, other than when you have a youth councillor position created, then there's usually a different age category below 18 for that. And it's usually 16 to 24 or 16 to 30 that I see communities talk about. Some communities also require a high school diploma. In a community I've been working with recently, they talked about having either high school diploma or a certain type of experience in community that has to do with governance and the delivery of services to First Nations people. Some communities ask that a person who runs not be eligible if they are convicted of an indictable offense, unless they have been granted a pardon by the government for that offense, or it was in relation to their exercise of Aboriginal rights. I've also seen exceptions be made in election codes with regards to people who have indictable offenses that they committed while they were young people. So it's under the Youth Criminal Justice Act that they were sentenced as a youth. One community I have has been very, very open, talking about their community's background experiences. And this is a sad, but I guess real experience, life experience that we have as Indigenous people, is the issue of sex-related criminal offenses in somebody's past. So in the one community I work with, they really wanted to talk about that and say not have been convicted of a sex-related criminal offense and not have been found liable in a civil case for a sex-related conduct of any wrongful nature. So civil case being an individual case by one person against the other, and a criminal offense being under the criminal code. Some communities also like to say that a person must not have been removed from council within a certain period of time before they run for office again. So once you have an election code, you get to create your own rules around chief and council accountability. And so when you create your own rules around accountability, you get to decide what would lead to a council member being removed from their position in office. And that's what this is talking about. Some other things that we see in First Nations laws is a person must not be allowed to run if they have resigned from office, causing the election. So you can't say, I quit, I'm walking, and then run in the by-election, for example. Persons not having a civil court judgment or criminal conviction against them for theft or fraud within the past certain period of years, unless they were granted a pardon or it was part of their youth record. And in one community I'm working with, they limited this further to say not have a civil court judgment or criminal conviction for theft or fraud within the past 15 years where the First Nation or First Nations member was the victim. So it was limited to situations where a First Nations member or the First Nation itself had been a victim of that crime or event. Some communities ask that persons not be eligible to run for council if they owe money to the First Nation, unless they're in good standing with regards to debt repayment. And so this has come up in communities that have situations where people have not been paying their mortgage or have not been paying their rent for long periods of time, and they owe money to the First Nation, but they're not willing to actually pay that money to the First Nation. This could also arise in situations where the First Nation has loaned money to a band member and the band member hasn't paid it back. And it could also arise in a situation where the First Nation has a legally binding order that somebody owe them money, or maybe somebody breached a contract. So the First Nation paid them for doing something in a contract and they never followed through and did the work. So they owe the money back to the First Nation because they never completed the work. So there's a lot of circumstances where this could appear. And some communities, this isn't a problem at all. They're not worried about arrears because in those communities, for example, one community said, well, it's not really our fault that our members owe arrears for not paying their mortgage or rent because they're on social assistance. We're in a remote area and the social assistance amounts don't allow for full rent payment to be made. So the social assistance that's been provided for shelter allowance on reserve has historically been very unfair. And when you have multiple generations of people living in a home, it has been the case in the past, at least, where you do not get multiple shelter allowances through social assistance. Even if you have 3 adults living in the home, you only get 1 proper shelter allowance and the others are treated as dependents in a way. So there's been some inconsistencies in past policies that people say it's not fair to punish people for that. Some communities have adopted, and I would say only one community I'm working with right now that has been discussing the idea of having this financial disclosure requirement and criminal record disclosure requirements, key here being disclosure. So it does not impact your ability to run if you are truthful about it, but it makes it so that there's transparency with regards to what you have to share with community in order to be a candidate. Some communities also talk about the no dual role, so not being allowed to work for the First Nation or for a business entity that is owned by the First Nation if a person wants to run for chief or council. Now I'm going to move on to a Supreme Court of Canada case that dealt with a situation where a First Nation had required a person to have a minimum level of education in their custom election law. This is a 2015 case in the Supreme Court of Canada, but it started long before that. So the First Nation was a community of approximately 2,000 people. It is located in Saskatchewan, and I have tried pronouncing this before, and I just don't want to try and embarrass myself. But if somebody knows the pronunciation, please do help. So Louis Taipotat was 76 years old and had a grade 10 education. He was the elected chief of the community for 27 years plus. And then during that later years of his term, the nation ratified its own election act. So this was in 2009, and they decided that to run for chief or councillor position, a person has to have a minimum level of grade 12 or equivalent of education, or a higher level than grade 12 of education. The First Nation held its first vote in 2010, and this person who had been running for chief and was 76 years old in the past, been in for 27 years, was restricted from running as a candidate on the basis that he did not meet the education requirement for eligibility. He brought his claim to the federal court, claiming that the grade 12 requirement was a breach of his rights to equality under Section 15 of the Charter of Rights and Freedoms. The issue before the Supreme Court was whether the grade 12 requirement in the First Nations Election Act violated the individual members' rights to equality under Section 15 of the Charter of Rights and Freedoms, because educational achievements are the same as discrimination based on race and age. So the court had to decide whether educational achievements are the same as a person's race or age. And the legal test that the court had to look at for the breach of Section 15 was, does the Election Act have a disproportionate effect on members based on what they say an enumerated or analogous ground? And does the Election Act fail to respond to the actual capacities and needs of the members of a group, or burden them or deny them a benefit in a way that will reinforce, perpetuate, or exasperate that disadvantage? So is there a disadvantage, basically, is a big part of the picture. And in the federal court, the judge decided that a person's education level is not beyond their control. So education requirements distinguish between members based on merit and capacities. They are unlikely to be indicators of discrimination because they deal with personal attributes, not characteristics that the person has no control over. And the court decided that the education requirement in that nation's election act is not discrimination based on race or age, and that the level of education is not an analogous ground to either race or age. So it can't be treated the same as race or age because it's just not similar enough. The idea is that race and age are things that a person has no control over, and education is something that people do have control over. Mr. Typotat then decided, I'm challenging this through to the Federal Court of Appeal. I don't agree with the federal court's outcome. And at the Federal Court of Appeal, the judge looked at evidence was put before the judge from Statistics Canada. And the evidence that was put before the judge looked at educational levels of Indigenous peoples. And the Election Act creates a distinction that discriminates based on both age and Aboriginality residence, is what the court decided. They said that the education gap within the on-reserve Aboriginal population of Canada is well documented, and that requiring a grade 12 education takes away the rights of a large segment of electors in the nation to run for office. The court said that there was a disproportionate number of elders and on-reserve residents who would be affected by the disenfranchisement or the restriction on their ability to run from office. In conclusion, the Federal Court of Appeal said the grade 12 requirement is a breach of Mr. Typotat's right to equality because it targets segments of members of the First Nation based on their age and Aboriginality residence, taking into consideration, of course, the Statistics Canada information about on-reserve education levels. The court talked about how this affects human dignity and the self-worth of affected individuals. It promotes prejudice and stereotyping towards them, in particular elders who reside on the reserve and have not had the same opportunities and advantages with respect to educational attainment that their maybe younger generations have had. And that the distinction that was made in having the grade 12 requirement is discriminatory because it has an adverse impact on older members of the community and on those people who live on the reserve who may have lacked the same opportunity as off-reserve members to get an education. They talked about in the Federal Court of Appeal decision the restriction that this grade 12 requirement created on access to being involved in the social and political affairs of the First Nation, and that people were being denied this opportunity to be elected to public office on a false view that because they are not sufficiently educated, they are less worthy. So elders, they talked in the Federal Court of Appeal about the traditional knowledge, wisdom, and practical experience that elders bring to the table, and said that these elders are being excluded from office simply because they have no European Canadian education credentials. So the breach of the charter can be justified as well. So the court said there was a charter breach. Absolutely, they said discrimination occurred. But then we have this other part of the Charter of Rights and Freedoms that says, okay, the first step is somebody has to prove that a breach occurred, that their right to equality was breached as an individual. Second, what happens is the court looks at, was that justified? And the court in this case decided that the grade 12 requirement in the law was not justified under Section 1 of the Charter, which sets out a legal test for justification. And the court talked about how the First Nation may have a pressing and substantial objective to encourage members to seek out educational achievements. So they had a legitimate objective in requiring the grade 12 education. However, the court said that the community was unable to show that the grade 12 requirement would help it achieve that objective. The court was not convinced that by having a grade 12 requirement, it would encourage members to seek out educational achievements. So the court decided that the section of the Election Act requiring grade 12 was void. It was not enforceable. That got brought forward to the Supreme Court of Canada by the First Nation. And the First Nation, and basically what the Supreme Court of Canada talked about was that they said there is no evidence between age, residency on a reserve, and educational levels being connected for the specific First Nation here. So this First Nation used statistical evidence from Stats Canada to make their argument before the Federal Court of Appeal. They did not provide any information to the Federal Court of Appeal about how many people on their reserve had a grade 12 education, about how many people off reserve had a grade 12 education. There was no evidence about the education levels of members of the First Nation at all that was put before the Federal Court of Appeal. And so the Supreme Court of Canada said statistical evidence is not always required to establish that a neutral law infringes Section 15, but the evidence has to be more than just instinct or assumptions. And they overturned the Federal Court of Appeal decision and said, yes, the grade 12 requirement stands. So why does this case matter to Witset? If Witset wants to include a minimum educational requirement for chief and council, it can do so, but it has some legal risk in doing so. And people who do not agree with that requirement may take it to the courts. They would have to make a challenge they could make a challenge based on Section 15, and whether or not that challenge would be successful is not guaranteed. They would have to gather enough evidence to prove which members don't have an education in the reserve, who would not meet the requirements, and they would have to show evidence that shows they don't have grade 12 education because of their age and because of where they live. So if a person was to make a challenge before the courts with regards to a requirement like this in Witset's election code, they would have to, then the Witset would then have to justify the requirement. They would have to show what is the reason why we have a grade 12 requirement. Is the reason we have a pressing and substantial objective? And is that pressing and substantial objective or reason that we've come up with connected to the requirement itself? For example, it could be that the pressing and substantial objective is to have people on chief and council who are able to read and understand the complexity of legal documents that they have to deal with on a daily basis, in particular with regards to Aboriginal rights and title or negotiations, complex business deals, etc. We have another case here to just go through quickly about the Federal Court of Appeal. And in this case has to do with a community that had created a requirement that in order to be on chief and council, in order to be nominated, you have to take up permanent residence on the reserve within 3 months of being elected. So this is Cowessess First Nation. If the person is not taking up permanent residence, then their position gets deemed vacant under the Cowessess Election Act. In this case, Mr. Lavallee was elected as a chief, but was unable to obtain a residence on the reserve within the 3-month limit. Another band member who had been evicted refused to move out of the residence that Mr. Lavallee was to move into. And as a result of Mr. Lavallee not physically relocating to the reserve within 3 months of election, 4 out of 8 of the councillors stopped recognizing him as the chief. They went to the federal court seeking an order that Mr. Lavallee cease performing all of his chief's duties and cease holding himself out of as a chief. Stop saying that he's the chief to the public, basically. The federal court decided that the Election Act was clear and unambiguous. There was no questions about what it said, and that there was a 3-month residency rule that he didn't meet, so his seat was deemed vacant. It's as simple as that. The court said the proper interpretation required him to be in actual physical occupation of a residence on reserve, despite any actions on part of other band members that got in the way of him doing so. And that Section 14.01 of the Election Act required that a by-election be called in these circumstances, so the court ordered a by-election. This was brought forward then to the Federal Court of Appeal. It was brought forward on various different arguments. It was not brought forward with regards to all the arguments that were originally made in the federal court. The Federal Court of Appeal was asked whether the federal court's decision was reasonable, and the Federal Court of Appeal decided that the decision was not reasonable. It said, the Federal Court of Appeal said that, looked at the phrase take up permanent residency. That phrase was not defined in the Election Act. So Mr. Lavallee had made all these legitimate efforts to get residence on reserve, and other people got in the way of him being able to do so. The court decided that the most reasonable way to interpret the words take up permanent residency would be to say that he had done everything he could to take up residency. And the court said that he was the chief and there's no need for the by-election to be held. Why does this case matter? Because if Witset wants to include a residency requirement, it has to be very clear about what that requirement is so that there's no ambiguity in the courts questioning it, and make sure that it's not just take up residence, live within the boundaries of this road and that road, or live within reserve number 1A, or it has to be very specific in order to be getting away from the issue that arose in this case. We have another case that went as far as the Supreme Court of Canada with regard to residency on reserve. And this one went in 2024 to the Supreme Court of Canada, so it's quite recent. And in this case, the First Nation is a self-governing Indigenous community in the Yukon. So it's a little bit different of a structure than what we have right now for Witset under the Indian Act, or what an election code is. It'd be a little bit different. Canada and the Yukon government had passed legislation that gave the First Nations a self-government agreement. And in that self-government agreement, it had the ability to create its own constitution. It created a constitution and said that all chief and councillors have to reside on their settlement lands in the village of Old Crow in their traditional territory, or if they don't reside in those areas within 14 days of being elected, they have to move to those areas. So in this case, the individual is a citizen of the First Nation, lived in Whitehorse, which is 800 kilometers south of the Old Crow Reserve, and was not able to move to Old Crow if she was elected because her son required access to medical care that was not available at the First Nations location of Old Crow. The person challenged the residency requirement and said that her right to equality under Section 15 of the Charter was being breached. One of the first things that the court had to look at was, does the Canadian Charter of Rights and Freedoms apply to this community that is a self-governing nation? And 7 judges listened to the case, and 4 of them made a majority decision. So there was a division in the court. 3 judges disagreed with what happened, but when there's a decision in the Supreme Court of Canada and not all the judges do not reach consensus, it's whatever the majority of the court decided that rules the day. So here they applied a legal test from another case called Eldridge, and there's a legal citation on there that you can actually copy exactly those words from Eldridge versus British Columbia Attorney General 1997 3 SCR 624 and plop it into Google, and you'll get the whole case, I'm sure, right, come up. But basically what they did is they took the test out of that case to decide whether the Charter of Rights and Freedoms that protects individual rights of Canadians applies to the First Nation. So is the First Nation a government for the purpose of the Charter applying against it? And basically the test was, is it considered a government by nature? And the questions the court looked at is whether the government is democratically, of the nation, is democratically elected by members and accountable to those members, whether it has a general taxing power, ability to make tax laws, for example, that is indistinguishable from the powers of Parliament in the provinces, so different from or separated from. Is it empowered to administer and enforce laws within a defined territorial jurisdiction, defined boundaries of territory? Does it derive its existence and lawmaking authority from Parliament, so from the Government of Canada, or from the provinces, the legislatures of each province? And does it exercise powers that the Government of Canada, Parliament, or the provinces would otherwise exercise? And this is to decide, is the First Nation itself even a government that has to follow the Charter? The second issue was whether the residency requirement does violate the individual person's right to equality. And the third question, and this is kind of the first time really that this has been looked at in depth by any court, is if the residency requirement is a violation of the individual person's right to equality, then is it protected by Section 25 of the Charter, which says that individual people's rights under the Charter cannot be construed so as to abrogate or derogate from any Aboriginal treaty or other rights and freedoms that pertain to Aboriginal peoples of Canada. So is there an Aboriginal right that is diminished if we treat this criteria around residency to be a breach of the individual person's right to equality? This is where you're looking at the conflict between Aboriginal rights and individual rights, and how the Charter of individual rights can protect people when there's Aboriginal rights that conflict with it. The person who relies on the Charter rights, so in this case, the individual who says her right to equality was breached, has to show that the requirement for residency breaches her individual Charter right. If she's not able to prove that breach, the Charter claim fails. There's no need to consider whether the Aboriginal rights should be overriding the individual rights because she fails at that stage. If she can prove that there's a breach of her individual right to equality, though, then the First Nation that is wanting to rely on Section 25 of the Charter has to show the court that the right that they claim Section 25 protection over is an Aboriginal treaty or other right. And when you look at other right, does the First Nation have some right that protects or recognizes its Indigenous difference as a First Nation? And then if the First Nation can show that, they have to show that they can't comply, that if they were to allow people who are non-residents to be on chief and council, this would conflict 100% with their Aboriginal rights, and it wouldn't be possible to do both. So what did the Supreme Court of Canada decide? The Supreme Court of Canada decided that the individual's charter right is breached by the residency requirement because it creates a distinction based on non-resident status in a self-governing Indigenous community, and it reinforces, perpetuates, and makes worse for the individual the disadvantage that already exists for non-resident members. And it decided that the First Nation, on the other hand, has established that the residency requirement is an other right. It is the nation has a right to set criteria for membership in their governing body, and that the nation's exercise of that right protects interests related to their Indigenous difference as a community or as a group of Aboriginal peoples, because what that does is there's a right to preserve the distinctive emphasis that it places on leaders' connection to land. So what the court said is that for leaders of the First Nation to reside on settlement land, this preserves their connection to the land, which is deeply rooted in their culture and governance practices, and that it helps to resist the outside forces that pull its members away from its settlement lands, preventing erosion of the connection of the land to the people. So the court decided that having the residency requirement protects the relationship between the First Nations individuals who lead the First Nation on its chief and council and their connection to the lands. and that permitting a person to reside outside of the settlement lands would diminish that connection and would undermine the person's connection to their land, essentially. So basically, the court decided that Section 25 of the Charter of Rights and Freedoms is protective. It shields the First Nation against any Section 15 right based on a right to equality that takes away from the First Nation's right, overall right to maintain this connection between its leadership and its land. And the court dismissed the claim. So here you see a situation where a First Nation used its Aboriginal treaty or other rights to protect it against a residency-based claim of a charter right infringement. And what this means for Witset is questionable, because there's a large majority of Witset members who reside off reserve, and obviously Wet'suwet'en territory too is quite large. It's not just reserve lands, and there's this other layer of Wet'suwet'en territory and how we have our Wet'suwet'en governance system set up that makes things a little bit more complex for Witset. But residing within the traditional territory and connection to the traditional territory could be something that could justify a requirement that somebody live within the territory in order to be on chief and council. Alternatives that other communities have looked at is requiring people who are on chief and council to be present within the territory for certain periods of time throughout the year. And that is time for discussion now. So looking at the various ways that things have been done in other government structures with regards to eligibility to be on mayor and council, eligibility to run for provincial office, other things that First Nations have included in their own election laws. What criteria should a person have to meet to run for council? Should there be any other criteria other than being a member of Witset and being 18 years of age? And this here question concludes the part of our presentation piece of today's meeting.